இந்தியன் கான்ஸ்டியூஷன் ரைட் பண்ணிக்கிட்டு இருக்கோம். ஸோ இன்னைக்கு the part 3, the fundamental rights. Section 10. It's a part unless the context otherwise require the state, including the government, the Parliament of India, the government, and the legislation of each of the states, of all the local and other authorities within the territory of India under the control of Government of India. Everyone is under the control of Government of India. Notes to Article 12. Instrumentality of state. The bank, being the instrumentality of the state, cannot be permitted to make discrimination or classification of employees who has voluntarily retired under VRS schemes and those who has retired under the same scheme declared by other public authority banks. Assistant General Manager, State Bank of India versus Radre Shyam Pandey. So state can't make a discrimination on classification of the employees who has voluntarily retired under VRS. Okay. Agency outside India. An instrumentality or agency of the state being operation outside India must comply with the Indian labor legislation. So even though they are operating outside India, they need to follow the Indian regulation. Leela Khan versus Union of India. Board of Control of Cricket of India, BCCI. The Board of Control of Cricket in India is a registered society and hence is not a state under the Article 12 Constitution Act. Cricket Association of Bihar versus Board of Control of Cricket of India. So it's not a different state, it's considered as a society which is part of India. Okay. It just registered as a society as a society, it's an individual, it's not a separate state. The BCCI is not financially, functionally, or administratively dominated by government, nor it's under the control of government. Therefore, it's not a state. Zee Telefilms Limited versus Union of India. So BCCI is not controlled by India. It can act as on a separate basis because it's a society. It is an individual. That is being given by the Zee Telefilm Limited versus Union of India. Example of statutory and other bodies held to the state. State Bank of India as also the nationalized bank as a state within the meaning of Article 12, the Constitution of India. The service of the workmen are also governed by the several standing orders and by party settlements which have the force of law. Banks therefore cannot take recourse to hire and fire for the purpose of termination of service of the employees. The bank cannot be recourse to hire and fire. A Bank of India versus OM Shwaranakar. So that is a case 2003. Children's Aid Society should be treated as a state within the meaning of Article 12 as it is undoubtedly an instrument of state. Sheila Barsi is the Secretary of Children Aid Society. So the Children Aid Society is considered as a state because it's within the Article 12. It was considered state. It's controlled by state. There are tests formulated by several cases of the Supreme Court to find out whether an institution is a state, and there cannot be indeed to be a straight jacket formula. Tarek versus Union of India. So there are many cases. BCIC, they are society, they can be that, but that Children Aid Society, it is also a society, but it's a trust that is considered as a state. So there are various sections which collapses people. So there are things. Other authorities. What is and what is not a state has been a subject matter of each case law under the Article 12 of the numerous jurisdiction of the subject. Judgment of Andhra Pradesh High Court was called up a certain propositions that B. Hussain Ali Khan is the Director of Higher Education, Andhra Pradesh. Judgment states that the essential test of determination whether the particular institution is another authority within the meaning of Article 12 or substantially financially controlled by the government, performance of public functions and interested by the government activities. All these are not essential, and it's a particular case one of the combination of more than one of them may suffice. In the leading case of Ajay Hasai versus Halid Muhib Registered Society, the Regional Engineer College is held a state by P.N. Bhagwati J. observed under the case. The constitutional philosophy as a democratic socialistic republic requires the government to undertake a multitude of social economic operation and the government hereby regarding the practical advantages of functioning through a legal device often corporate impacts on migrate commercial economic activities by the resorting to the instrumentality or agency of corporation. By this contrivance of carrying on such activities through a corporation cannot exonerate the government for its basic obligation to respect the fundamental right not to override them. The mandate of the corporation may be adopted in order to free the government from intervening constraints of red tapeism and slow motion, but by doing so, the government cannot be allowed to play truant with the basic human rights. Otherwise, it would be easiest thing for the government to assign to a pluralable of corporation almost every state business such as post and telegraph, TV, radio, rail, road, and telephones. In short, economic activities thereby cheat the people of India out of fundamental right guaranteed to it. This may cheat the people, so they will all be in the flow. The above judgment of Supreme Court, Justice Bhagwati enunciated the following test of determining whether the entity is an instrumental or agency of the state. One thing is clear that if the entire share capital of a corporation is held by a government, it would go a long way towards indicating that corporation is instrumentality or agency of a government. And a financial assistant of the government is so much as to meet almost entire expenditure of the corporation, it would afford some indication of the corporation being implicated into the government character. It may also be revealed further whether the corporation enjoys monopoly status, which is a state conferred in a state protection. Existing deep and pervasive state control may afford an indication that the corporation of a state agency or instrumental. If the function of the corporation of public or importance is closely related to the government function, could be relevant factors to classify this corporation as an instrumental or an agency of government. Specifically, if the Department of Government transferred to a corporation, it would be strong factor support of the inferior of the corporation being an instrumentality or agency or government. The Delhi Transport Corporation is a state of Delhi Transport Corporation versus Maghdur Congress. So the TCL is not an authority within the Article 12 of Constitution. Jatiya Pal Singh versus Union of India. Under mentioning decisions as may be seen in the connections. Som Prakash versus Union of India, State of Punjab versus Rajaram, Shukdev versus Bhagatram, K.S. Ramurthy, Reddyar versus Chief Commissioner, Sabkati versus Union of India, N. Mastam Shabir versus Chief Commissioner. These are the cases. And going so more, you can say a private body. A private body which is agency of the state maybe the state. Star Enterprises versus State of Industrial Development. So private body is an agency of the state. Okay. Duty of employer. The employer within the meaning of Article 12 of Constitution has an sacrosanity duty to act in terms of sacred objects of the social and economic justice. State of Jharkhand versus Haridhar Yadav. The private unnamed minority schools, not state. The unnamed private minority schools are not state within the meaning of Article 12 of the Constitution, as even then the government has no administration control because of their anonymity under the Article 30 subsection 1 of the Constitution. Satyabal Sharma versus St. Paul Senior Secondary School. What is a state? If a state is defined in the Act, it's not confined to government of department and the legislation, but extend to an action, administrative, judicial or quasi-judicial, which can be brought into the fold of state action, being action which violates fundamental right. See the under-mentioned decision. These are Ramya versus International Airport Authority of India, Gululam versus State of Uttar Pradesh, Som Prakash versus Union of India. Even the private bodies may be a state, that is even Mahavir Auto Stores versus Indian Oil Corporations. State action. The historical context in which the doctrine of state action involves the US is irrelevant of India. But the principle behind the doctrine, state aid, control, regulations also, are so interpreted to private activity as to give a color of state action. The interest as to limited extent to which it has been Indianized and harmonized blend into the constitution pre-judicial. MC Mehta versus Union of India. The sovereignty function. Mere dealing in a subject of the state or a monopoly or the state of particular field would not render an entrepreneur sovereignty in a nature. Balmer Lorry versus Co Limited, Warren Lorry and Co Limited versus Bharata Sarathi Sin Roy, Agriculture Produce Market Committee versus Ashok Harikuni, Assam Small Scale Industry Private Limited Corporation versus JD Pharmaceuticals, Haryana State Industrial Development Corporation versus Hari Om Industries. Sovereignty of function is dealt with helped in the monopoly of the state in a particular field would not render the enterprise sovereignty of nature. That has been given in the sovereignty function. State to aid fairly. The state is required to act fairly, giving a due regard and respect to the rules framed by it. So there is a rule that is framed and the state should act within the rules. Bhupendra Nath Harasika, the state of Assam. The law inconsistent with in a derogation of the fundamental right. All the law in force in the territory of India immediately before the commencement of the constitution, in so far as they are inconsistent with the provision of the part, shall be extended to such inconsistent be void. The state shall not make any law which takes away or abridges the right confined by the parts, and any law made in the contravention of the clause shall, to the extent of contravention, be void. Is the article unless the contact otherwise required. Law includes any ordinary or order, bylaw, rule, regulation, notification, custom or usage as you having the territory of India and the force of the law. So law is defined. What is in law? That is actually an ordinary, ordinance, or order, bylaw, rule, regulation, notification, custom or usage having in the territory of India the force of the law. That is law. Law in force, what is that? Includes law passed or made by the legislature, another component or authority of within the territory of India before the commencement of this constitution, not previously repealed, notwithstanding that any such law or any part therefore may not be then in operation either at all or particular areas. Law in force. Nothing in the article shall apply to the amendment in the constitution made under 360. If there is this law doesn't apply, in this article shall apply. If there is an amendment in the constitution under article 368. So these are the things. So thank you for listening, for giving fair and valuable 12 minutes to me. Thank you for your time. Take care. Bye.